Thank the member of opposition and call on the leader of opposition to conclude.
I think we've said enough thank yous. Let's get into voting issues. I have 5 of them. At the top of the debate, I want you to go to their criteria of justice, which they defined as giving each what they're due, and extend it across. Because I am going to focus every issue in this round through the lens of their criteria, through the lens of justice. And what I think you'll see is that in the end, while the status quo may not provide everyone with justice, the government's advocacy gets a net decrease in justice for everyone. Yes, certain people are hurt by 3 strikes laws. However, everyone is hurt by jury nullification. Let's go to the first voting issue, which is, again, the bigger, broader picture that they hurt justice overall. That proves that they're not upholding their own criteria and is the reason you reject them. Because they can't uphold their criteria, I don't want to hear about how wonderful rehabilitation is in the PMR, because that's not the criteria you're weighing this round on. You're weighing this round solely on the criteria of justice. Do they uphold justice? And I contend they do not. The second voting issue is the court clog. Court clog hurts justice for many ways. Because yes, if I appeal my 3 strikes decision to the Supreme Court and they strike down 3 strikes laws, yes, I personally have sat in jail through 3 trials, but now every other person subject to 3 strikes laws doesn't have to sit in any jail because the 3 strikes no longer applies to them. Take a look at the Violence Against Women Act, which the Supreme Court struck down last year. They did not just strike down the Violence Against Women Act in the case of Ms. Bronson-Kala. They struck it down in its entirety and said the Violence Against Women Act is no longer the law of the land. This proves that one Supreme Court case can be the equivalent, one appeal can be the equivalent of hundreds of trials at the local level that depend on a jury. Furthermore, do you realize that because right now most people take a plea, but if they think they've got this shot at nullifying the jury, they're going to rush to the jury system. They're going to try to get a trial, and as we've shown you, the court system is overclogged now. If you've ever even gone for a traffic ticket, you know how clogged it is just at that level. You realize that if everybody starts jumping in the system, then everybody's justice is delayed. We delay justice for everyone, which is a net decrease in overall justice. The third is that the rule of law position. I would argue that you cannot have justice. Justice cannot exist without the rule of law. Ask people in Iraq how their justice is. Ask how it is in any communist or rather non-democratic state what their justice is. You will find you get a better justice for all overall in a democratic society by upholding the rule of law. And the rule of law, as we see, is key to a stable democratic process as demonstrated by Bush v. Gore. The jury is the key to a stable rule of law. As I tell you on the case, which is the term, you increase inconsistency, you increase racism, because I'm asking the same jurors who passed the 3 strikes law now to nullify it. Now, if I'm lucky enough to get 12 people who voted against that law, I get off. But if I get 12 people who voted for it, I don't. Justice is denied and it's applied unequally, and more so than in the status quo. The fourth voting issue is that they can't solve, so they can't increase justice. As I just pointed out, you're asking the very people who supported the 3 strikes law in the first place to vote against it. But furthermore, since in all felony trials, you are not allowed to know the previous conviction history of the victim. You have no idea, or of the defendant, you have no idea if this is their 1st strike, if this is their 3rd strike. So the jury can't nullify anyway. They'd have to nullify every single time on the assumption it was the 3rd strike, and what that means is that we get 0 justice. No person receives justice if every single jury acquits every single defendant on the fear that this might be their 3rd strike, and that decreases justice. And the 5th and final voting issue is the tyranny of the majority hurts justice. The unresponded answer is that if you can nullify 3 strikes law, then you set the precedent to nullify hate crimes legislation, to nullify EEOC legislation. You can say any law isn't just. Therefore, the majority opinion, the minorities who most need the protection, get denied because of the racist system. They themselves tell you the criminal justice system is racist, and I tell you that racism is further perpetuated, hurting justice for everyone. For all of these reasons, I would urge an opposition.
Thank the leader of the opposition and call on the Prime Minister to conclude the debate.
Assembled. I think we're going to just jump right into this. I'm going to talk just real briefly about the 5 issues that have been brought up. Now, the first of these is basically the idea of what people are and are not due. So since those relate to everything else in the speech, I'm not going to make that a separate point. So we're going to jump to the second one, and that is the idea that we're combining the system. What I'd like to point you back to is Chad's specific analysis that this stuff has been around for quite a while, and it hasn't happened. Nothing has happened yet. He said specifically that, I think his specific rhetoric was that the problem with the Supreme Court overturning this is that it has to be unconstitutional. And so until there's some indication that the Supreme Court is going to rule this as unconstitutional, that it's going to see it as unconstitutional, that it's going to bring it up there to the Supreme Court, agree to hear it, and then overrule it, there's absolutely no reason to believe that you're going to get any solvency off of the opposition's advocacy. That being said, and I can't make it any plainer because it was just bottom line, a completely unrefuted level of analysis that was on that particular disadvantage, I think that that entire argument, level of argumentation goes away. In addition to which, I'd like to turn to the next one, which was the idea about the rule of law. What also goes unrefuted on this one was the idea that this entire premise is to check the system of abuse. Chad told you specifically that the reason it's more important to have the justice than to have the consistency is because if you're consistently unjust, if you're consistently unfair, then that is a bad thing. Consistency is not a good thing in and of itself. And so when we tell you that the only alternative that you have here, the only alternative that's been presented in this round, is that on a case-by-case basis, you actually look at the act and you look at the intent, then at that point you create a better system of justice. You create more justice in terms of net benefit than you do if you oppose today's resolution. The fourth level of analysis they give us is that we don't have any idea about their solvency. And I thought this was really interesting because this argument kind of changed a little bit from the first moment it was given until the last moment. First it was, but defense lawyers do everything they can. They do the best thing that they can do in order to make sure that you don't know about it. That does not equate to what came out of the Leader of Opposition's second speech, which was, you never know as a juror whether or not a person is ever convicted. He said they do their best, and that was the argumentation that we've been basing this entire round off of, and I asked you to make them stand by that. They will do their best. Yes, it will not be perfect. No, it won't. But the bottom line is that it's a better situation than leaving people rotting in jail, waiting for somebody, one of these thousands of appeals, one of these thousands of cases, to finally make it to the Supreme Court. And that makes for better justice. The final idea is this idea of the tyranny of the majority. And I think that this is really interesting because, once again, they dropped Chad's very clear analysis that we're talking about a parametrization of today's round, that we're only talking about 3 strikes you're out policies, and that you're not applying this across the board. If they wanted to object to the parametrization, they should have done it right up front. It should have been a procedural issue, and they didn't do that. Chad told you specifically at the top of the case that there's absolutely no objection to the parametrization, and so all of the analysis that this is suddenly going to become a huge conflagration that's a great big problem simply goes away. That's the end of that. So, that said, let's turn to the reasons I think you're going to affirm today's resolution. Now, the first one, and he's right, I am going to get up here and talk about rehabilitation because I think it's really important. Because when they allow the 3 strikes you're out policy to stand, when they say no jury shouldn't do anything to try to circumvent what is admittedly an unjust law, they completely delegitimize rehabilitation in the criminal justice system in general. If you go back to the original rhetoric that I gave you out of my first speech, I think it was, as soon as you commit a crime, you are a criminal for life. Because everybody is just watching and waiting. And it doesn't matter what you do from there on out, because as soon as you hit that third point, you're going to be nailed. Not with the penalty that you would normally apply, but with this other much greater penalty that you're only open for because you already had a criminal background. And we think that that is extremely unfair to say that you have to have that double standard on when this is enough justice and when this is enough justice. That does not reflect justice, and that is something that overturning these and that having jury nullification provides for. The second issue is one that came out of the member of opposition speech when she asked you specifically, what is the obligation of the jury? Well, I think that this is really important. She says this was a referendum and it's the obligation of the jury to uphold the law. I would say that because this law was highly contested, because this law was not really, really popular, this was something that they had to really push to get through. You also have an obligation on the part of the jury to recognize that they did not take act and intent into account, that they don't know this, that they didn't know the specifics of what kinds of penalty or what kind of crimes this was ultimately going to be applied to. That is the obligation that the jury has, because in that time and place, that jury is the only alternative that that person has. That's the obligation of the jury. It's not like all of California was jumping up and down on this. It barely passed. The final thing that we can look to here is the idea of act and intent. So bottom line, what is the basis of our jury system? What you want to do is you look at the act that was committed and you look at the intent that they had. At the point that you completely divorce both the concept of act, as Chad clearly explained, what really wasn't refuted, because you don't look at what they actually did, you just look at what number of crime it is. And because you completely divorce the concept of intent from it as well, because you don't look at what they intended to do, you once again only look at which numbered crime it is. The bottom line is that you get a better jury system and a better justice system if you allow the jury, if you encourage the jury, in the case of a three-strike throughout policy, to reject that and to nullify that law.